Very good morning, all of you. Let us start our today's session on cybersecurity and laws. All of you are requested to kindly update your details in the chat box, UN number, name, and the roll number. Okay, so coming back to what we have seen so far in the previous lecture before the Diwali, we have started and we were speaking about understanding of the module number 4, which was the concept of cyberspace, and then we have taken something on an e-commerce. Then we went it ahead and understood what is a contract, and we stopped the self on the last part, which was the various types, or you can say about the various types of an e-contract. So we were started with the first one. There were three types of e-contract. First one is the shrink wrap contract. Second one was the click wrap contracts, and third one is the browse wrap contract. So if you remember, we have started with the first one, which was a shrink wrap contract. So let me just start my PowerPoint presentation so that we can take it forward. Meanwhile, all of you are requested to kindly add your details in the chat box, your UN number, your name, and the roll number, so that our attendance gets counted. So let me just turn on my screen. Yeah. So if you remember, we were speaking last time on a shrink wrap contracts, and in that, if you remember, we have seen that how shrink wrap contracts works. So in a shrink wrap contracts, that if you have, let me just turn on the laser pointer. So we have seen that how if you open the package, it means you are consent to be bound by its license agreement, and if you do not agree to the license of the agreement, you can return the product unopened. If you open the product, then you are liable for the license contract. So that is nothing but the shrink wrap contract, right? So if you have not opened it, you are not under the agreement, and you can return the unopened item purchased for a full refund. After the shrink wrap contract, this again an image which I am showing, that if I have opened this CD, then you say that yes, you are bound to, and you have read and accepted the agreement, and then you are bound to an agreement. Similar to shrink wrap contract, the second one is the browse click wrap contract. Okay. So when I say a click wrap contracts are contracts, there are click through. It means they are mostly found as a part of a software. The user generally has two options, whether to accept the offer or whether to decline the offer. It means user can either accept the terms and conditions of the agreement, or user can decline the terms and conditions of an agreement by clicking on the relevant button. But I know we all of us are so much busy in our day-to-day life. We only remember one point. Whenever there is an accept, you need to accept. When there is an agree, it's an agree. Never ever we have actually taken efforts to taken pain to read what does the agreement be like. Um, so probably if I have time, I wanted to share one real example that happened because of not actually reading the terms and conditions, and how vulnerable it can be. So it is always probably if I have a time, I will show it, tell it to you. But otherwise, these terms and conditions are always important, and you have two options, whether to accept or reject by reading the terms and conditions. It is called as click wrap contract. By accepting or by clicking it, you give your consent. Next type is the browse wrap contract. It means this type of agreement is normally used or found on a website or the home page of a downloadable product. Sorry. So the user has to accept the terms and conditions in order to further browse the website or to download a resource by clicking on the recent button. So if you can see here, yes, I agree. So if you say yes, I agree, then you can go further. It's a browse wrap contract. You can only browse the website, or you can only download a resource provided you click on the relevant button. That comes under the browse wrap contract. So this agreement is generally found on the website or the home page, which you want to accept the terms and conditions to do that. Okay, so that is browse wrap contract. So going further, what are the actually law when we speak about the contract? So if you see, based on the contract, you have an Indian Contract Act of 1872. Just see the year, the Indian Contract Act of 1872. So this is the contract right from the year of 1872, based on the contract. So Indian contract defines the term contract under the section 2H. So if you can see here, you have 2A, 2B, 2C. So if you can If you search on the internet, you will also get an Indian Contract Act 1872. In that, in 2H is the section which is based on the contract, where the term contract is used, which is saying that it's an agreement which is enforceable by law. By law is a contract, right? So, an agreement which is enforceable by law is a contract. So, the Act governs the manner in which the contracts are made and executed in India. It provides a framework of rules and regulations which governs the formation and performance of the contract. So the rights and duties of a parties entering into the contract and the terms of this agreement are decided by the parties itself. So Indian Contract Act, if you can say, it's one of the oldest law of our country. It came into effect on 1st of September 1872. And this law of the Contract Act is applicable to the entire India except Jammu and Kashmir. So this law is applicable to the whole of India with the exception of Jammu and Kashmir. This Contract Act has probably 266 sessions, 266 sections, sorry. So it has a total of 266 sections, and its principal law is regulating contracts in India. So the keyword expressions and the meaning related to contract is all of them is given, where you have a different sections: 2A, 2B, 2C, 2D, and so on. So 2A is some in which section which discuss on the offer. So for example, when one person signifies to another his willingness to come into a contract with the view of obtaining the assent of that other to such act, he said to make a proposal, right? So that comes under 2A. 2B is the acceptance of the contract. It means when a person to whom the proposal is made signifies his assent that he is ready and his proposal is said to be accepted, right? So whenever the person to whom the proposal is made signifies his assent, then it said that the proposal is accepted. That is section 2B. 2C. So in 2B you have an acceptance also, and 2B you have the promises also. So what is promise? A proposal when accepted becomes a promise. In simple words, when an offer is accepted, it becomes a promise. It means that needs to be fulfilled. So whenever a proposal is made, and if that proposal is accepted, it's a promise that yes, this contract is going to be there. Section 2C speaks about the promiser and a promisee. So when the proposal is accepted, the person making the proposal is called as a promiser, and the person accepting the proposal is called as a promisee. So that comes under the section 2C. Section 2D is consideration. When at the desire of the promiser, the promisee or any person has done or withdrawn from doing or does or abstains from doing or promises to do, we called it as consideration for the promise. Price paid by one party for the price of the another, for the promise of the another, that comes under the section 2D. 2E is an agreement where every promise and set of promises forming the consideration of each other. And 2H we have already seen is a contract, which is contract is nothing but an agreement which is enforcement by law is a contract. Therefore, there must be an agreement and it should be enforceable by a law. So the different terms and the different sections and different definitions, you have it of an Indian Contract Act 1872, which I will be giving it to you for a reference that you can have it. Or otherwise, even if you type on the internet the Indian Contract Act 1872, you will get this from the internet as well. Okay. So these are the some contract act or the law which is there as an Indian Contract Act in 1872. Right. Next one, security aspects of cyber law. Now, what are the security aspects of cyber law? Now, in the security aspects or the security is concerned of the cyber law, we are going to speak on this. Information technology has entered, as you see, all walks of life today. I hope everyone agrees, right? So we have the information law, and the information law or the information technology has entered all the walks of life. So everything we do is on an internet nowadays. The advent of the internet, social networking, we have also seen an e-commerce has increased the amount of data that we generate. Maybe the business deals, online transactions, exchange of the data, all are being done electronically through an internet. So ensuring the security of these transactions and data is a great concern, because there is a new challenge when it comes to cyber security. So there should be a legal infrastructure is required to protect the data, to protect the information, and to protect the IT infrastructure. So for that, we make use of a digital signature. Now, what is a digital signature? Digital signature is a code generated using public key cryptography, also called as asymmetric key cryptography. So anyone who know what is the use of a digital signature? I think probably computer students will be able to answer this. What is the use of a digital signature? Why we make use of a digital signature? No problem, even it's wrong. Even other stream students also can try. I'm not saying no, but then I'm expecting that even computer students should answer at least. Anyone? Super Mohit. Mohit, very good. How Mohit you come to know this? Very good. Very right. So it is for integrity, it is for authentication. And one more thing which your digital signature provided is is the non-repudiation. So what are these things? I'll let you know, but very correct. It is used for integrity, it is used for authentication. Very good. Yes. So digital signature is a code generated using public key cryptography, and this is attached to the electronic document, which ensures that the receiver of the electronic document about the authenticity of the sender. So if you want to know the authenticity of a sender, or even if you want to know the integrity of the data, and if you want to know the non-repudiation, we make use of a digital signature. So electronic signature can be anything. It can be scanned handwritten signature, which you place on an electronic document, or it can be a mouse click. So you can say it is nothing but an electronic sound, symbol, or process that is attached. We have already written. It's a code that is attached to the electronic document, which ensures the receiver of an electronic document about the authenticity of the sender. Right? So that is what. Very good, Mohit. So Mohit has answered. That is very good. Right? So it is again a part of a digital signature. So digital signature is mainly we use because for obtaining all this information. Right? And the main reason is for the authentication, integrity, and non-repudiation. Now, what is this? I'll tell you probably in the next slide when we are going to see it in much more detail. Now, what are the legal architecture for the validity of a digital signature? So all type of transaction over the internet, especially the internet, need to address the issue of related to authentication, integrity, and the non-repudiation. So when I say authentication, it means I want to authenticate a user. Integrity means to ensure that the document is not been tampered, and the non-repudiation means a person tomorrow cannot later deny that he has not sent an information. Right? So I will explain the concept of non-repudiation more clearly when I'll be taking an example of the certificate authority CA. So what is certificate authority and what is the use of a certificate authority we are going to see. But the non-repudiation is tomorrow a person cannot deny later that he has not sent a message. Right? I'll give a simple example. For example, for non-repudiation is suppose you have purchased something on a Flipkart today. So you have purchased a mobile and you have opted for a cash on delivery. So what happens is after you opted for a cash on delivery, obviously then mobile is going to come at your place, right? Uh, yeah. So yeah. So as I was saying that, for example, if something is given to you, now what happens in this case? Probably if you have given it and if you have ordered something, Flipkart is going to give that order at your home. And tomorrow, if you deny that you have not purchased, you said, I have not ordered this. Somebody on my name or somebody with my identity might have placed an order. So it should not happen. If you have done this, that should be justifiable that this has been done by you. So there is no repudiation. So that has been followed, right? So you do not have that much in detail, but just I'm explaining so that for your understanding. So these issues can be dealt with the use of a digital signature. So you have a public infrastructure is an approach for enabling the use of a digital signature. For that, certification authority is responsible. So here you can see something CA is written. CA stands for certificate authority, and the certificate authority issues the digital signature certificates. Now, when I speak about a certification authority, it is under section 17 of the IT Act 2000. So if you want to see about certificate authority, you can open IT Act 2000. In that, there is a section 17. So under section 17 of the IT Act 2000, the controller of certifying authority, that is CCA, the controller of certifying authority, which is appointed by the central government, they are given a license to license. They are given the rights to license and regulate the working of CA. Right? So under the section 17 of IT Act 2000, the CCA, that is the controller of certifying authorities, has been appointed by the central government to license and regulate the working of CA. Correct? Okay. Yeah, sorry. Yeah. So I was saying that they have a rights to give this. Now, CA are the person uh, uh, who issues a digital signature certificate for electronic authentication of users and promote the growth of e-commerce and e-governance through the use of digital signatures. So it is the responsibility of the certifying authority to issue the digital signature certificate. And then digital signification certificate is because used to provide authentication, integrity, and non-repudiation. So let us see what are the licensing of certificate authorities. So when we speak about the licensing of certificate authorities, as I said, under section 87 of the IT Act 2000, there are some rules that are being mentioned by the central government to regulate the application and the guidelines for CA. Now, these rules are called as IT Rules 2000, and it deals with the following issues related to CA. First, creation and verification of digital certificate, IT architecture that CA must support, information that digital signature certificate must obtain, and the eligibility for licensing of CA. So these are the certain things that are being taken into consideration probably when we speak about these rules which is defined and which is of licensing of certifying authorities. Now the question comes, when we speak about licensing of certificate authorities, what the certificate authorities can do? The certificate authorities can check the validity, renewal, and suspension of the license granted to CA. It can also have conditions which the controller may refuse to grant a license or refuse to renew a license. It may also be used to check the security guidelines for CA. It may also define the fees that CA can charge. So certifying authorities can also decide the fee that the CA can charge for obtaining a digital certificate of any client. Plus, it can be used for generation of digital signature certificate. So all these things are being used for licensing of a certifying authority. So certifying authorities, or I can say the certificate authorities CA, are the person who is responsible for granting a digital certificate to a website to which a consumer can make a communication. Right? For you to remember. So who are the listed licensed CA? So when we see there's a list of licensed CA, there are a lot of licensed CA. So if you want to see, you can go to website cca.gov.in /licensed CA. You will come to know what is the list of licensed CA available, in which you have a SafeScript, IDRBT, Sport Solutions, eMundra, CDAC, NSDL, Indian Air Force, Indian Army, CDSL Ventures. There are few of them which are listed on this. You can find who are the trusted CA and who are the licensed CA who has a license to provide a digital certificate. Now, regarding the sections that are concerned, you have several sections that are been there. So, Section 8 of IT rules, that is the Information Technology Certifying Authority rules. You have a licensing of certifying authority. So, for that, you have it in the IT Act, IT rules of Section 8, where it specifically provides the requirement to apply for a grant of license to issue digital signature certificate to an individual and company. So, for that, you have a Section 8 of it. Section 35 of an IT Act 2000, where a certifying authority CA can issue electronic signature certificate. For that, you have a Section 35, and we'll see that in detail in the next slide. Okay, so Section 35 is an IT Act which describes that you can say this section lays down the requirement and procedure for obtaining a digital certificate from CA. So if you want to obtain a digital certificate for CA, for that, it is also been given in Section 35 of IT Act 2000. Really sorry. So if you can see, this section lays down the requirement and procedure. So you can see any person may make an application to the CA for issue of a digital signature certificate in such form as prescribed by the central government. So any person can make an application to the CA for granting a digital certificate. You can even see every such application should have a fee for granting a digital certificate, and that fee should not exceed 25,000 rupees. So if you want to procure, you can have a fee, but that fee should not exceed 25,000 rupees, or as may be prescribed by the central government to be paid to the CA. So CA cannot have their money. Whatever money they want, they can have it for giving a digital certificate. They had to work as per central government, and they will decide how much rupee to charge for issuing a digital certificate. Plus, again, different subsection, different section, different categories or different class of applicants had different fees for a digital certificate, and that have it in the statement which has been mentioned. Clear so far? Any doubt? I hope it is clear to everyone. Any doubt so far? So we are okay. Thank you so much, Mohit. So we are today in 29 in strength. Very good. So I'm very happy. Yeah. So let us go first further and let us. Okay. Thank you, Sakib. Yeah. So let us proceed further and let us understand on an intellectual property. What is an intellectual property, and what do we consider in that? Uh, Now let us go into understand an intellectual property aspects in cyber law. So intellectual property refers to the non-physical property, that is creation of the human mind. So being intellectual property, it means an intangible property. It means non-physical property on which you can apply this law. So when I say it is a non-physical property, it means it can be a creation of the human mind. So anything or any property that is the creation of a human mind is a part of an intellectual property. So being intangible, being non-physical, protecting intellectual property is very much difficult because they can easily be stolen and may be difficult to recover, leading to monetary loss and leading to loss of reputation. Right? So intellectual property rights aim to provide the innovators and those who are the creator of the information the legal protection for their idea and the legal protection for their creation. So intellectual property deals with the right where the rights are being done not to a physical property, but to a property which is non-physical. It means that is the creation of a human mind. So it is there to provide the innovators and the creators legal protection for their ideas and creations. So this can be done using a copyright, maybe by applying a patent for inventions, or maybe a trademarks. So intellectual property encompasses two types of rights, or I can say probably industrial property rights, where you have your trademarks, patents, and the copyright. Copyright is normally been done on an historical, dramatic, artistic, creative work, films, and musical work. So there you have the intellectual property. So let us see what are the types of an intellectual property. So intellectual property, the following are the types of intellectual property. First one is the patent. A patent is an exclusively right which is granted by a government to its inventor, which allow him or her to exclude all others from making, exclude all others from using, and excluding all others from selling the invention for a limited period of years in exchange for the public disclosure of the invention. Right? So patent is there to protect the information, to protect the inventions, and which will exclude anyone who wants to make, who wants to use, or who wants to sell, or you want to import the invention. That is prohibited, right? So in India, patents are governed by the Patent Act. We have a Patent Act 1970. So just think the year. So patents are governed by the provisions of the Patent Act 1970, and then it was amended by the Patent Act in 2005, and later it was amended into Patent Amendment Act 2005, and then the Patent Acted Rules of 2006. So the term of when we speak about a patent is 20 years. So the term of every patent in India is 20 years from the date of filing of the patent. So whenever you have an invention and whenever you file your patent, then you have a 20 years for that patent. So the term for each patent is 20 years from the date of filing, and the patent rights are granted by the Indian Patent Office and extends only throughout the territory of India. Just remember this: for the grant of patent only in India, Indian Patent Office extend only throughout the territory of India. Now, for the grant of patent in another country, the inventor must apply in that specific country. Right? So in this case, in India, the Indian Patent Office is administered by the Office of the Controller General of Patents, Designs and Trademarks. So in India, the Indian Patent Office is administered by CGPDTM. I'll repeat again. In India, the Indian Patent Office is administered by CGPDTM. If you want, you can write it down. What is CGPDTM? That is Controller General of Patent, Design and Trademarks. What is the meaning of patent? See, Chaitanya, patent is normally meant then it's exclusively right given to someone's invention. So tomorrow, if you have a new invention, so probably tomorrow you have a new invention and you have made, for example, you have made a car that actually flies. So it's a new invention. You that For that you might create a patent so that nobody else can copy, nobody else can make it, and nobody else can actually create a copy. Nobody can sell, and nobody can take your invention. This invention belongs to you, and you have made it. Clear? Yeah. Sheikh, uh, sir in Ram and Sham, if third person also not give money, then what will happen? uh, See, whenever we speak about the trusted third party, he is always a person who is a trusted. That is the reason we say it's a trusted CA, right? What is the meaning of trusted? Trusted means he's a trusted party. It means somebody is making a trust on him, and since he is a trusted, he's charging for that. A CA issues a digital certificate and he's charging for it, and he is there to provide a certificate. So before providing a certificate, even a CA will not give a digital certificate as it is. He is going to check various parameters. On various parameters, if that website is found to be genuine, then he's going to assign a digital certificate, and then he assigns a digital certificate. It's then the responsibility of CA to ensure that it cannot be done, right? Because it is not a single client who is trusting a CA. CA is somewhat a listed trusted source with which ensures the security. So it is the person who actually grants a digital certificate, and then it is a someone trusted third party. So I've just given an example of a money, but the case is not of a money. But the thing is, he's there to ensure that a digital certificate exists, and it is only the publicly cryptography with which the consumer is going to make a communication with. So sometimes what happens is, suppose there is a user who wants to do any payment transaction on a Flipkart, right? But I am worried. For example, if I am buying any mobile from a Flipkart, but then on the other side, I am worried whether I am sending my credit card details. Is it going only to Flipkart, or this credit card information will receive to some a fake website or some fake user, and then my money will get debited and I will never get the mobile in exchange of that mobile phone. So you have a trusted website, you have a trusted third party CA which provide a digital certificate to a company, and that get he attaches as a part of a public key, and that is circulated to the user, so that user have a guarantee that yes, he is actually communicating with the Flipkart, and then if he is using the services, he is going to get back the resources. That is the reason it is making a use of it. I hope I was able to answer you. Clear? Okay. Yeah. Welcome. Yeah. Thank you. So let us go further and try to understand. As I was saying, we were speaking about CGPDTM, right? Now, this is a subordinate office for the government of India and which administers the Indian law for patent, design, and trademarks. Now, let us see what is a trade secret. Trade secret is an intellectual property in the form of a formula, in the form of any design, in the form of an instrument, in the form of any process, or the information which is generally not known to a public and using which a business can obtain an economic advantage over a competitors or a customer. Such a business also makes efforts to maintain the secrecy. I'll give an example to make it more clear about the trade secret. So, for example, when we speak about a trade secret, uh, as I said, let's say an example of a Coca-Cola company. Now, Coca-Cola always have a trade secret that what are the ingredients or what are the mixture used to make a soft drink. That is a secret to a company, and since it is a secret, it is a source of a business for a company. So tomorrow, if that gets breached, if somehow tomorrow anyone gets the formula for making a soft drink, then there will not be a secret. So that comes under the trade secret. We'll stop it here. We have less than a minute left. We'll join back in the next session where we'll continue. Those who have still not updated the details in the chat box are requested to kindly update the details, UI number, name, and the role number in the chat box for your attendance. Let's join back in the next session after 2 minutes.